transfer of Mr. Francis Baden and the recommendation of judges for consideration for elevation as well. Those were the three bases upon which we saw that recommendation go to the president, and a request as well for the removal of the CJ. But we also know that the CJ, in terms of the timelines and what it is that we've seen, she's challenged that impeachment process all throughout from May of this year. She, on the 21st, had a writ of summons at the Supreme Court, which is yet to be determined, an injunction application which was unanimously dismissed on the 21st of May 2025 as well. Also, what we know amongst many other things, on the 9th of June, she was in the High Court for a judicial review on the processes during that Article 146 committee. She said that her rights were being violated amongst many other things. The committee proceeded with its work nonetheless, but she went in July, the 4th of July 2025, to ECOWAS and filed a case at the ECOWAS Community Court. She filed a case again in July seeking a judicial review against Shining Stars, one of the many groupings which had petitioned for her removal. And then after the recommendation of the Scott Poaman Committee for her removal, she went to the High Court again, arguing that she being removed as Chief Justice, if you read that notice which removed her from the bench in totality, she's arguing against this and making the case strongly that, look, being removed from office as Chief Justice did not mean she automatically lost her place as a justice on the bench of the Supreme Court. Hence, she was asking the High Court to, amongst many other things, quash the president's notice for her removal as a justice of the Supreme Court as well. And now we're seeing the latest as well, where she's challenging the entire workings of the Article 146 committee and the petitions brought against her, where she makes the argument that the findings in that report and the recommendation is false, misleading, irrational, and illegal because it cites misconduct for expenditure that was neither disallowed nor surcharged by the Auditor General. Again, she makes the argument that the first finding is unreasonable and unfair because it attributes unauthorized expenditure to the Chief Justice, though she neither authorized nor administered it. Again, she says that the second finding is an abuse of power and unconstitutional as it wrongly treats the Chief Justice's lawful administrative duties under Article 1254, including the transfer of judges and officers, as misconduct. Again, this is her fourth reason. And if you're on Facebook, you're following with me as we continue along the way in terms of the arguments based upon which the CJ is in court this time around. And the fourth argument she says is that the third finding is an abuse of power and unconstitutional as it mischaracterizes the Chief Justice's legitimate role under Article 1254 and established conventions in judicial administration as misconduct. Again, she says that the third finding is also unlawful as it challenges the Chief Justice's conventional role shared with the Ghana Bar Association and Attorney General in recommending judges for promotion. Tanko Rashid Computer Al-Hajj is joining us on the telephone lines this morning as well as we begin a dissection of what it is that was seen play out from the quarters of the former Chief Justice. Mr. Tanko, I appreciate you joining us. Good morning. I trust that the weekend has been kind.
My brother, let me say good morning to you and your cherished listeners.
I hope that all is well with you.
Everything is going on well. as a government, everything is working on well for the good people of this country. So we are keeping our eye on the ball to make sure that Ghanaians continue to enjoy their labor.
Labor of which they are seeing the city perform creditably against the US dollar. I'm sure that's a feather in your cap as a government.
Of course, that is what I'm saying. We are keeping our eye on the ball as a government to make sure that His Excellency John Dramani Mahama promised Ghanaians he was going to make their life better. And he continues. For the past 10 months he's been in government, unprecedented since 1992. We've never seen this type. I mean, a new government like that been in office and was able to keep the economy in check for the first 10 months in government and not even having one single scandal anywhere in a part of his government. That tells you that he's keeping his eye on the ball. And then I think we need to congratulate him. We need to hold him in high esteem as he's been held globally currently. I mean, he's doing the work that our first president, His Excellency Kwame Nkrumah, was doing, and this evil minds terminated his reign in 1966. And so, for us, it's like there's a reincarnated of Kwame Nkrumah in the body of His Excellency John Dramani Mahama, and Ghanaians are testifying it. It's all over the place.
Right. Let's get into the CJ's latest. You in the NDC have not hidden your how do I put this? You've not shied away from the position that she had to go. Hence, though you argue that you had no hand in terms of the petitions which went to the president, you believe strongly the president took the processes as required by Constitution, which resulted in her removal. She seems to be of a different opinion and is challenging all of the processes that saw her removal from office as Chief Justice. What are you making of this latest application as filed in the High Court?
As a political party, the NDC is strongly behind His Excellency John Dramani Mahama in the decision that he took the matter of this former Chief Justice. I mean, we strongly support him as a government, as a party. I mean, we believe that he went through the due process. No constitutional article has been breached. I mean, nothing was done against the Constitution of this country. He followed through all the process. The process has been petition received, prima facie established, a committee set. She appeared before the committee. The committee came out with a report, and then the president is bound to implement the decision of the committee, and he did just that. I mean, so for us, we believe he did justice to the process, and he's upholding the tenets of the Constitution. And then we strongly support him. But let me tell you, the former Chief Justice is involved in judicial lawlessness. I mean, this is what we call judicial lawlessness, an abuse of the court process.
But she has a right to go to court and to challenge all other matters.
It's an abuse of the court process. You have the right. But you see, you don't abuse it because she used to be the head of the judiciary. She knew all these processes. And she has time and again warned lawyers not to abuse the process. And that is what we are seeing. I mean, nobody is preventing her from exercising her right to file all manner of this suit in any of the courts. Nobody. As a party, we will not prevent her from doing that. But she shouldn't abuse the process. You know, a lot of young lawyers are learning from these processes. Now, when we are teaching them, these young lawyers who are now coming up, learning, they are in law classes, studying, and they are following through this, what are we teaching them? To abuse the process? To hold the country into ransom? That is what she's trying to do. Preventing the nominated Chief Justice from being vetted What she stand to gain from that?
But it's
an abuse of the process.
It's a process of which that is a part of. She's seeking to challenge the 146 committee work which removed her from office because she believes a wrong was done here, and in so doing, she must seek to stop the appointment of a new Chief Justice because she believes in the country's judicial system and the fact that the court will quash the committee findings and as well the notice to her which removed her from office. Hence, a new CJ must not be appointed because she believes she could return. There's nothing wrong with that.
That's why I'm saying legal luminaries have discussed this matter and they have concluded that she's abusing the process and that she's involved in judicial lawlessness. Because this is not her first time of filing such processes, even at the Supreme Court. And it was dismissed unanimously. When she questioned the legality of the committee, so set by the president at the Supreme Court, it was dismissed by her own colleagues at the highest court of the land. And so why will she turn around and look at what she's doing? It's just to hold the country to ransom. And that is what we are saying as a party. We support His Excellency John Dramani Mahama. And that is what we think Ghanaians are all looking up to make sure that we have free, fair, transparent judiciary processes in Ghana. And that is why, as a party, we've never interfered in this process at all. We've never. The NDC did not put its hands in this matter at all, so that somebody would think that the NDC is so much interested in the removal of the former Chief Justice. No, we never. And then so we just wanted to make sure that we, as political watchers, were watching through the process. If there was anything untoward, we would have raised it as a party. But we didn't find any. We found out that the president was doing the right thing. He followed through the right process. Is it saying that the prima facie that was established, the body that established it, was not constitutionally mandated to do that? Is that what he's trying to tell Ghanaians? Go and look at Article 146. The processes are all lined out there. The same Chief Justice, former Chief Justice, you remember Professor Kwekwaza, in December, wrote similar petition against her for her to be removed. Nana Akufo-Addo, then president, went through the same process through Article 146. And they came out that the verdict that they didn't find any case against her. There was no prima facie case against her. That's how the matter was dismissed. But this time around, the Council of State found prima facie case against her. He should not be allowed to govern. An impediment must be put on his way. What is it? We still don't understand. We don't get it. I mean, if you look at all this, my layman knowledge in legal things and processes and all that, that reading, go and look at 146 and you read it, I don't see any technicalities in that article that warrants all of this back and forth and all that. I think senior people, senior citizens in this country must call the former Chief Justice to order. Because what is going on is not good for the democracy of this country. It doesn't help anybody.
Right. Let me bring in Christian Malmhesi as well. He's a private legal practitioner who's joining us this morning on our conversation. Counsel, I appreciate you joining us as well. The NDC believes this is an abuse of the court processes. She's filed one too many, and you heard him say that she can't hold the country to ransom. What do you make of this latest from the Chief Justice? You also believe that at some point she's got to let this go?
Good morning to you, and good morning to your listeners and your co-panelists. Indeed, the point must be made that to start off, when one says that she is holding the country to ransom, I beg to differ, because just as the Constitution envisages, an ordinary citizen of the land is enjoined to assert her legal rights to the fullest of whatever due process. Once the Constitution has made that procedure available to whoever, it must be exhausted to the barest minimum. It cannot be deemed as one holding the country to ransom. I mean, it is the exercise of a private right. How does it hold the country to ransom? I mean, that is stretching the point. And to come to the processes that she's filed, she's rather doing the country a good service. I mean, constitutional experts, or if I would say, students of constitutional law would get to benefit by way of posterity from what Justice Torkornoo is doing. Because this is a situation that has happened, and with the myriad of things happening throughout her procedures, it has never happened in this country. We have had the urban situation and all of that, but the uniqueness of her case has never happened before. And it is affording us opportunity to have legal precedents that would guide constitutional law and administrative law. And when we are getting this rich precedent for judges to make pronouncements on, that would guide the future conduct of Article 146, I wonder how one will say she's holding the country to ransom. When we are having the opportunity to build such a rich judicial precedent, and for us as lawyers and persons interested in jurisprudence, also jurisprudence, this is a very interesting situation we find ourselves in. And we will encourage it, because at the end of the day, law is philosophy. Philosophy is love for wisdom or knowledge. And that is it. At the end of the day, Article 146 committee, even though there are a school of thought that holds that it does not come under a committee or a commission of inquiry, which by creation of statutes indicates that it is appealable to Court of Appeal. But when you come to Article 146, it does not exist. Once you even have a school of thought, means that there should be a pronouncement on it, because the otherwise of it ventures one school of thought to hold that by way of that you cannot have a judicial review in that situation, no matter how one could deem the committee having conducted itself, whether properly so called or not. So that if one holds that the committee did not adhere to established procedural processes, or there are human rights violations, the administrative procedures, which probably are upheld by the Constitution, does it mean that that person cannot have the opportunity to quash it by judicial review, or have it otherwise determined by the High Court that has supervisory jurisdiction and Article 141? It is intellectual. It is intellectual situation that we find ourselves in. One would say intellectual masturbation. It is a serious situation where the court must interrogate the legal processes. Indeed, under Article 146A, it deals with issues of in camera. A school of thought holds that once a judicial review is occasioned, then it will defeat that purpose. I am very interested in wanting to know what the position of the court is, to say that indeed, given the fact that it is in camera under Article 146A, then we do not have jurisdiction to go into it.
Right.
It's one of an interesting case. That is why I hold that humble view or position that once it borders on precedents which would guide us going forward, because we have never been confronted with this unique situation in the jurisprudence or in the constitutional jurisprudence of this country. Why should we throw it to the gutters and say that she's holding the country to ransom?
Right. To the
point, we become averse to constitutional litigation. No. She's exercising her private rights as a citizen of the land.
At what point, the question is, at what point does that right come to an end? Because there are those who are of the opinion that she's relitigating matters, some of which determinations have been made on. For instance, she's been to the High Court for a judicial review on abuse of process by the committee during its work. That process or that review was dismissed. And
yes, you realize that if you interviewed me on that, at a point in the course of that, and I pointed out that it was premature because the process at the time was unfolding, was ongoing, and to run to the court to say all of that, it was never going to stand the test of time. That was how I envisaged it. And indeed, the court threw it out. And I concluded that it would rather make meaning, should the process complete, for her to come by way of judicial process. My soundbite is in your record. You can bear me out. And indeed, that would be her last option. I also put that on record. If this position as she's putting, and that is legal ingenuity. That is legal ingenuity or smartness, because at the end of the day, as one school of thought holds that it is not provided under Article 146, and it is specific when it comes to committee of inquiry. She had also maintained that Article 146 committee should be deemed as committee of inquiry to deal with it. And that is why I am for it, that the country would get a rich precedent that would guide us going forward, especially when we know the inherent flaws with Article 146. I've spent a lot of time dealing with the jurisprudential flaws associated with Article 146, which I will not bore your listeners with it by rehashing that particular argument. It is right now amongst the public what the flaws of Article 146 is, or lovers of law who are not lawyers, of the flaws associated with Article 146. That's Article 146, but that is not the subject matter today. The point is that, is she entitled to a judicial review? My point is that she's a private citizen of the land, and she has every legal right to assert her position. To the conclusiveness of it, I have heard some arguments say that some eminent persons met her so that she would throw in the towel from the onset, so not to go through all of this. She would have resigned, so that was, they were calling for her resignation. She would have resigned as the disgraced judge. She was not ready to go for it. She has a conviction. Allow the individual.
Right.
She's a private citizen. She should be allowed, because there's no law that fetters her position of asserting the court.
Right.
So why should that be a problem?
I want to come in here on the reasoning upon which she's seeking this review, where she's, amongst many other things, challenging in entirety all three findings against her as basis for her removal. We've had conversations time without number on this particular subject matter. She continues to hold the firm belief that, look, the conclusions as arrived at by this Poaman committee was unfounded, and she should not have been removed from office as a result of that. That you believe the High Court has the powers to have this turn around in her favor?
So that's why she is going by way of judicial review and citing all the lapses in the procedures adopted. She's citing flagrant violation
of her rights.
Yeah. Yes, of her rights and all of this. And all of these things come under the reason to come back for judicial review. Now, if the court comes to a conclusion that the court agrees with her, then that would mean that it would be interesting to conclude that the decision of the committee will be thrown out. That would be the reason of the court to go that path. Will be interesting for all of us. Should the court decide to throw her out and cite the reasons to protect Article 1468 in camera and all of that, that will also make a good reasoning for us. So, as students of law and as members at the bar interested in jurisprudence or constitutional law, we are interested and keen to know which post the court would hit the ball to, and that is one of interest.
Right. Let me bring in Tanko again. Alaj, they say let the court processes play out. She has a right to it, and in the end, vindication will lie in the womb of time, because all of this is going to help build up our jurisprudence as a country.
My brother, let me. I totally disagree with counsel over this. Nobody is asking that she has no right or preventing her from exercising her right there in the Constitution. No, nobody is preventing her from that. But you don't abuse the process. She's a former Chief Justice, former head of the judiciary, so she knew this. Look, you started mentioning all the processes she filed. In fact, we have even lost count of some of them. And all the processes she filed, they dismissed them one after the other, to the extent she went to ECOWAS court. What was he trying to establish? I've just looked at it. I said, I'm a layman in this field. But just look at Article 146, Clause 6 of it. And it's very clear as to how the process went through. Where the petition is for the removal of the Chief Justice, the President shall, acting in consultation with the Council of State, appoint a committee consisting of 2 justices of the Supreme Court, one of whom shall be appointed chairman of by the President, and 3 other persons who are not members of the Council of State, no members of Parliament, no lawyers. Was this one not established? When the prima facie case was established against her, was this committee not established? What was wrong with the committee?
She says the processes, there were abuses of her rights in the process of the committee hearing, and that the conclusions arrived at are unconstitutional and it breaches her fundamental human rights, because she can't be penalized for doing her work as a Chief Justice, which is the argument she makes, that some of the decisions arrived at by the committee penalizes her for her work done as a Chief Justice.
It was very clear that from the beginning, she knew what she was going in for, and she knew that the work of the committee was supposed to be in camera. Learned Counsel is here. Let Learned Counsel explain that thing to the general public. Why was she asking that the thing should be made public? The sitting of the committee should come public. Was she not asking for constitutional lawlessness? Was that what she was looking for? Because she is the guiding god of the Constitution when she was the Chief Justice. And yet the Constitution made it very clear that the sitting of the committee must be in camera. Yet this former Chief Justice was looking for an opportunity for the opening of the doors of the committee for the general public to see what was going on. Was that not a lawlessness? And these are the things we are talking about. And so we are saying that as we learn from Learned Counsel and their group, lawyers and all that, they should let us also go along with them. Then let us retard the development of this country through this kind of legal gymnastics. But these gymnastics are just there to waste everybody's time and waste the country development opportunity that we are going to go through. Is it in the interest of anybody to have the office of the Chief Justice being vacant? Is it in the interest? Is that what they are looking for? Is that what the Lord envisaged? And we are saying that she has every right to go to court, but don't abuse the process. But she's abusing the process, and by so doing, she's holding the whole country into ransom. Because with all the processes she's filing, now she's preventing the nominated Chief Justice from being vetted. Is that in the interest of what the law is looking for? And these are the problems. And we are saying, as a political party, we won't allow anybody to use her whimsical interest to retard the development of this country. That is what we are talking about. We are not preventing her from exercising her right. She has every right to do what she wants to do with the court process, but she shouldn't abuse the process. And she shouldn't bastardize the committee which was formed from the Constitution. In fact, it's grounded. Article 146, Clause 6 of it is grounded there. And the people so appointed were very much qualified based on that article.
Right.
And they did their work.
So, if I may say one,
right.
Before you go.
Yeah, Councillor, I was just going to come to you so that we wrap up on this.
So, in wrapping up, the point must be made that he's not challenging the formation or the constitution of the committee, as Sir is saying, Mr. Tanko is saying.
Yes.
She's not challenging the constitution of it. She's challenging the procedures. She's challenging her rights. She's challenging whether or not they followed rightly with certain things. So it is the process, the procedures, the things that were raised against her. Things that she believes that did not meet the standard of law. As to the rightness or otherwise of it, it is for the court to determine that. You understand? And again, once he said that as a political party, this is their position and all, that's what I understand, because he's the politician. For me, I am the lawyer, and I am interested in the constitutional outcome. Just as today, we can refer to Ghana Bar Association versus Attorney General. We can also refer to Asif West case versus Attorney General. It would be the same tomorrow for us to refer to Justice Torkornoo's case. And this is how constitutional development or evolution comes off in a state. So when we say the Constitution is a living organism, this is how it is, because when situations happen, the Constitution is interpreted to respond to the current situation of life as the persons or society is evolving. So if the Chief Justice, the former, believes that indeed she has a case, as to whether or not she indeed has a case, it is for the court to determine it.
Right.
And whether it's an abuse of the court process.
That will be determined by the court as well.
Yeah, that will be determined also by the court, because it is a legal term. It is not just an English term that is but the process that she has filed, the court will determine whether this forms part of the abuse process or there is any merit in it. And the merit would find whether all the release will be granted or part of it will be granted. And then we see as that. So it's good day for constitutional law and administrative law.
Right. Just finally on that injunction bit, because that will come up, and that's dominated the conversations before I bring Mr. Langdon into the convention as well.
So with the injunction bit, you know that then she has a legal right. And
yes,
that legal right is obvious. That in injunctive applications or injunction applications, the first thing that the court will look out for is what is your legal right. So if your legal right is identifiable, then we look at irreparable damage, hardship, and all those things, about 5 elements. So in this situation, the first legal right is that if this application is to be heard, then the process ongoing should be halted, because if it goes on, it will defeat her should she win her case. So it goes without reasoning, and it is for the court to see the merit in it and identify her right and say that, okay, all right, let the constitutional process in appointing the new Chief Justice be halted, such that the acting, the acting would not lose anything should he continue to act. But if he's appointed as a substantive Chief Justice, it will now be upset or unconscionable when Chief Justice Torkornoo comes off victorious and will now have to unwind what has been done. So these are some of the things that the court will be looking at in the logic of the law.
Right. Let me bring in Mr. Langdon now. He's in studio with us. He's a member of the communications team of the United Party, Philip Langdon. Mr. Langdon, thank you very much for joining us in the studio as well, and for joining in the conversation. You always say you're not a member. You are a party.
I am not a communication team member.
Right. You are just a member of the United Party.
I am a vice chairman.
Okay. Oh, fantastic. You're the vice chairman of the United...
vice chairman.
A vice chairman of the United Party as well, joining us in the studio. And we've been hearing from our two gentlemen, the council, and as well Mr. Rashid Tanko Computer, on the latest from the former Chief Justice. Where do you stand on all of this? A waste of time? Her rights being exercised? Where do you stand?
Well, thank you very much. Good morning to you, to your viewers, to lawyer Ma'am Hesse, and also to my brother Rashid Tanko Computer. This matter is a legal issue. And like with all legal issues, there are always two sides to the story. And on both sides, you hear very cogent legal arguments on both sides defending their position. So I don't want to even go into that matter. On all issues, when people are taking a decision, you look at whether it's legal, ethical, moral, or sometimes even sensible. I've heard Ma'am Hesse giving all the necessary defenses for this case to be heard, while acknowledging the consequences, how the nominated Chief Justice cannot be vetted and sworn in since this case is going on. And of course, I've heard the other side too,
the best in the
where
is on
for a lot of people, this thing sounds like
on 3FM.
A deliberate attempt to waste everybody's time. At the end of the day, nobody can take it away from the former Chief Justice to embark on this line of action. We have chosen to go into a democracy, so we have to live with some of the consequences. It is for her to decide, and she has decided. If I was in her situation, I think I would have taken a different decision, because it's
which decision would be what?
As to whether to challenge this situation in court, because some situations might be legal, but you should also think about other parts of the same decision. Now, it's not everything that, if, for example, you have an issue with your employers or your neighbors or your landlord or somebody, you can choose how you handle it, whether you want to take him to court, whether you want to resolve the issue, or how else you want to deal with it. That is your choice. She has taken a path that, frankly, in the minds of a majority of Ghanaians, is a decision that is not particularly... I don't know how to put it. A lot of Ghanaians don't appreciate the need to go that way, just to put it nicely, you know. But it is her choice, and she has taken a decision which nobody can take away from her. So I believe that once we have chosen a democracy, these are some of the things we have to live with. My personal wish was that somebody would have advised her, if she herself couldn't take that advice, that this matter, because it would appear as just a deliberate action to waste everybody's time, like
Tanko says.
You know, and that's how a lot of people view it, irrespective of political positions.
Right.
So, in any situation, anybody's going to take a decision. You have to weigh all these issues and take your decision in such a way that people will appreciate the real merit of your decision, rather than think otherwise about what you're doing.
I appreciate your thoughts as well. We're going to switch lanes quickly and get into the NSS course names, because we know last week the AG was in court where he was putting Mr. Osei and then Gift Yowari before court, but the trial could not kick off proper in the proper sense of the word. That's our next conversation for the morning. Perhaps I'll start off with you, counsel, on that, so that we can get the groundwork in terms of the legal education as to what we saw play out. Writs were filed, but the report was that some of the persons who are to stand trial were not present, and that they had not been served of court processes, and the fact that hearing was expected to start. How did all of that mix-up happen based on your experience in terms of what happens in the court? Well, it does appear Counsel Christian Mamhesi might not be with us.
Hello.
Yes, you're with us.
Okay, all right, sure. So, I mean, when in criminal proceedings, once charges have been preferred against someone, as in a suspect, that person needs to be in court so that his or her plea will be taken, and after the plea, there will be the judge or the court would ask the defense counsel to pray for bail, and after that, the court would reach out the conditions for the bail, and then the court would direct that the prosecution serves the accused, because once plea is taken, it now changes from suspect to accused person. And after that, the court will direct that disclosures should be served on the accused person through the lawyer. And when that is done, so then a date will be taken as an adjourned date. And when they come back, there would be CMC, and then the trial would commence on another adjourned, or will commence on another date for the next adjourned date. And then, the trial continues from there. If there's a submission of no case after cross-examination by the accused person of the witnesses that the prosecution will bring forth,
right?
Then it follows as that until I don't want to bore the long procedure.
But in the case of Mr. Asibentry, his lawyers informed the court that he had not been directed by the police, or he had not been served with the charge sheet, which outlines the specific allegations, reason for which he could not be present.
Yes, definitely. The reason for his presence, as I mentioned, would be that charges have been preferred against him. So if there are no charges, or there's no, and those charges is contained in a document called the charge sheet, which is normally drawn by the prosecution. So they present it, and when the person comes to court, the first thing that the suspect would be made known after he mounts the box is for the court clerk to read out the charge sheet to him, that on so date within the territorial jurisdiction of this court, it did that. And so the facts would be read, and then the charges with the counts and all that would be read to the person. And then the plea will be taken, guilty or not guilty, and other things with explanation and all of that. So once the charge sheet, which plays a very crucial role, in fact, it acts as the commencement of the whole criminal proceedings is absent, then an agenda date must be taken.
And I'll bring in Tanko now, because this is a big case in terms of the NDC's oral agenda. We saw that Gift Yowari, a 2-day medical excuse duty. There are those, some of which are your supporters, who say that excuses are already coming up for some of these individuals not to face the court, amongst many other things. As a party, how are you handling these expectations on cases like these, even as the expectation is that these persons will also receive a fair trial?
Hello.
Yes, sir. You're
You see, some people are so wicked to the extent that their own parochial interests supersede the interests of the whole state. I'm saying they are so wicked to the extent, look at the quantum of money involved in this. If not wickedness, what else will you describe this? Completely wickedness. Look, I just came from the rural area yesterday. I visited most of the communities. I was checking on this, our rural telephone network. And I can tell you the number of communities with that network, only God knows. And one or two persons will be keeping such money in their coffers, wrap the country to this quantum of money, and yet the whole country is suffering. Do you know what 1 million or 2 million Ghana cedis can do to such communities if given to us, an agency, to extend network to those communities? In fact, we are anxiously waiting for the day, their day in court. This is wickedness. And look, everybody must stand up. I know the legal process. I am very much aware of the process involved. But you see, we will not allow somebody to use legal gymnastic or court gymnastic to derail this process, so that justice will not be served to the good people of Ghana. Justice must be served to the good people of Ghana. These are the things we do, and the country is stagnant. It's not going anywhere. How can two people look at the amount involved in it? Why? Why did they do all these things against the good people of Ghana? Was it a crime to vote MPP into office? What crime Ghanaians did against them? For us to suffer this kind of illegality against the good people of Ghana, it's terribly bad. And as a political party, we are disturbed. And we are happy the Attorney General is taking the bull by the horn to make sure that not only prosecute them, but recover the loot. This time, that is what we should do. It's not about prosecuting the people, but they must ensure that they recover every penny from these people. So we use it for the good people of this country. The people need water. They need network. I've been inundated. Every day I can't sit in my office. Network problem all over the place, communities. Then you ask yourself, in another bill, somebody used $58 million. Go and dig a hole in the name of God. Do you know what $1 million can do to these communities who are suffering from these bad network and water challenges? And yet, when they are going after them, then people are saying they are persecuting them, that they are persecuting them. In fact, they must go all out for them. They must use all legal means under their ropes to make sure that the state recover this loot from these people and go further to prosecute them, so that when they go and serve jail term, they will come out without any penny. We have seen this severally. People will loot the state, and then in the event that they are sent into Sawam, they come out in the next 4 or 5 years to continue enjoying the loot, because the loot will be waiting for them. They just want to go and cool off. Because of hectic work for 8 years, they think that after 8 years, even if I go and cool off for 4 or 5 years, I can come out and I have all the loot there. I will continue to enjoy with my people. And they will be there making noise. This time too happy. We must recover all the money. Recover everything. All the things they use the loot to acquire, the state must go after it. And in the event they get prosecution and conviction, they must make sure that they go and suffer in Sawam and come out penniless.
Mr. Langdon, where do you stand on when the trial possibly could start in the face of the first day in court and the judge having to adjourn indefinitely?
Where do I stand?
Where do you start? I mean, in terms of not stand.
First of all, a lot of Ghanaians are happy that the process is in motion to recover some of such resources that have gone into such areas. So that is very relieving for a lot of Ghanaians. Also, it is good, and they themselves, these accused persons in court, must be thankful that they have been given the opportunity to go to a courtroom with the counsel of their choice to defend themselves. They must be grateful, because as we all know, there was a time in this country you wouldn't even have had that chance. The moment it's established that you had done some of these things, I mean, the consequences would have been brutal.
Right.
Yeah. So, and we've all gone against that style of doing things. So, they have got their day in court, and they must be prosecuted. And yes, as much as possible, all that money that has illegally taken should be recovered and properly applied for the good people of Ghana. So as for that one, I don't think there's anything about where does one stand or where doesn't one stand. It is a very clear matter that everybody should stand for. That they must, they must have their day in court. And where the evidence has been led to establish what every effort should be made to recover the money. So far as I'm concerned, it is not a debatable matter or anything like that. This is very clear.
Right.
This is something that Ghanaians are looking to, to see. Lately, we've been hearing, even from within the ranks of the ruling NDC. That the Attorney General himself was under pressure. That, hey, they were expecting to see results. But then he too, he's a top lawyer. He's not going to be in a hurry to send people to court when he hasn't got a good case. And even the fact that these people went to court and, how can somebody be asked to go to court and he has not even been said? That shows the kind of pressure that such a simple error could have been made. But anyway, they are working. Let's just hope things are done right. They have a fair chance to defend themselves. Where they're not able to defend themselves and they are found guilty, the necessary processes are put in place so that the recovery is done.
Right, Counsel, there's a concern that we could see technicalities delay a number of these trials. And I'll come to you because you want to make that point as well, Mr. Langdon. There's a work, I won't call it a work, there's this comparison done by Same Dako, who is communications, head of communications at the office of the OSP, making the point that averagely every criminal trial spans roughly 3 years at the court, and use the Agrada case as an example, asking Ghanaians to be patient and manage their expectations when they demand that corrupt activities and corrupt individuals be punished. Do we run a risk of persons' expectations being too high to start off with, whilst also trying to deal with clear attempts by some of these individuals in some cases to delay matters before the court so that possibly your government comes and then you're left off the hook?
What I would say is that the Attorney General is a chief state lawyer, and the Attorney General can always enter into or make a prayer before the court for expeditious trial. The Agrada one went the normal way, through delegated prosecution. And under the Constitution, the Attorney General has delegated roles to the police and other parastatal institutions that carry out prosecutions on his behalf. Now, in this particular case, where the Attorney General is very, very interested in, the learned Attorney General can always make a prayer for the court to have this case put on a fast track for determination. And it will definitely be for the court to find reason with it so that it will be expedited. Indeed, where a charge sheet has not been served on the other, I'm sure it is administrative lapse that would be corrected in no less of a time. And a date as agreed by the parties would be when they will appear before it. And they will just have a case management timelines on the running of the case. And this has been done in the past, and Attorney General continues to do this. So it is not one that will leave the normal lifespan. So we have the normal lifespan of cases where such arrangements are not done with the court, that we are taking adjournments in and out as normal cases. But where the state is very interested in it, the learned Attorney General can always enter into that arrangement with the court to have the case heard expeditiously without delay or any kind of thing.
Without the you had wanted to say something in relation to this.
Yes. I forgot the other side of the question you originally asked me. That and that was to do with how the case is going. I think counsel has just spoken a bit about that as well. President Kufuor's time, remember, there was so much clamor like now.
Fast track courts.
So he brought the fast track court. He went further in beginning to expand the infrastructure of the judicial service. So we saw this huge court complex that was built in Accra and many others around the country. Subsequent governments have also endeavored to do the same. Also, they've decided to go digital to speed the process of case handling, so that the normal long-hand way of handling cases will also be removed and the process shortened. Now, the issue of some of the people behaving the way they behave, I think it is not peculiar to Ghana. Many countries around the world, especially in political cases, when people are on trial, you find people suddenly become very sick and things like that. Even in courts, people have been seen to collapse and all kinds of things have happened. Like some situations that we saw in Nigeria where somebody suddenly collapses, he's almost dead, and then he pleads that he wants to go and pray. They take him to a room to go and pray, and he stands up and he's bending down and praying but at the moment he finishes his prayers, he goes back on the stretcher so these things have been happening. I think that the managers of these cases must bear these things too in mind, that some people will want to take advantage of the situation in all manner of ways, so that they'll delay the process. So it is for those prosecuting these cases to bear all these things in mind and find ways to counter.
Right. I'm just going to bring us some news that's just coming through from the Office of the Special Prosecutor having to do with that case involving Mustafa Hamid and some 9 others. The Office of the Special Prosecutor says it has increased the counts against the 10 from 25 to 54.
Wow.
That's just coming through. Perhaps I'll just read verbatim the latest that they've just dropped. The Republic versus Mustafa Abdul Hamid and 9 others. Summary. The Republic has filed 54 criminal charges against officials of the National Petroleum Authority and several associated companies for alleged large-scale extortion, abuse of public office, and money laundering totaling 291 million cedis plus. I'm not going to go through all of the figures. And $332,000 respectively. The accused are alleged to have extorted hundreds of millions of cedis and foreign currency from bulk oil transporters and oil marketing companies under the guise of official duties, and subsequently laundered the proceeds through property acquisitions and business entities to conceal their illicit origins. I'm going to skip the accused persons because some of them are known, but perhaps I should just do that. Mustafa Abdul Hamid, Jacob Kwamina Emwa, Wendy Newman, Albert Ankran, Isaac Mensah, Bright Bidiako Mensah, Kwikwa Boaji Aqua, Propness Limited, an entity, Kel Logistics, and Kings Energy Limited. What we also understand is that there's been seized assets or frozen pending trial, vehicles including tanker trucks, fuel stations, houses, apartments, and parcels of land valued at over 100 million cedis, is what the OSP says has been seized. Perhaps because we're in the line of oral and corruption, I'll just pick quick thoughts from all of us. Let me start off with you, Mr. Tanko, on this latest that's coming through from the Office of the Special Prosecutor, which I've just read details of.
Yes, my brother, I am saying that we must support the OSP, the Attorney General Office, to go after these people and retrieve all these things from them. People were so wicked against the good people of Ghana. Just imagine the amount of money, the quantum of money we are mentioning. You know what it can do for this country. And then so that's why I support Mr. London for what he's saying.
We must adopt that fast-track process to retrieve this. Look, otherwise they'll use this, legal gymnastics, court gymnastics, to delay this process to the extent that we will not even get justice. Those are the things they are involved in. I am saying that they must go after them. By now, some of them should be cooling somewhere. And then the state will go and look for them. Because we know what the state can do about this matter. And I have confidence in the Attorney General. In fact, the learned Dr. Aini, he knew very much that these people, they have cases to answer. And so when we're talking about it, Ghanaians are not seeing the reality. They are not coming to terms with the kind of wickedness the MPP appointees did against Ghana, the good people of Ghana. Now look at how the country is. Just go and see the road networks. 8 years. These people, look at what they did. Nothing. Completely nothing. Yet they were looting the state resources left and right, nyafu, 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 all over the place. And today, when you talk, they say you are persecuting them, that you are chasing them for nothing. Meanwhile, they have cases to answer. They themselves, some of them behind the scene, are returning some of the loot. Right. And we're not going to stop there. I'm not surprised with the new charges being brought against these people, because the information I have about these people, the thing they did over there, that is why they say it is only when the frog dies that you see its full length. Now the frog, it's about, we are now about to see the full length of the frog. A lot are coming. And we'll make sure that we'll go after them and collect all the loot. Nobody is going to get away with it. The state must benefit. In fact, the good people of Ghana are hardworking people. I travel around the country, and I see how people are working hard to make sure that this country is the type of country that we all want to be. And yet, some handful of people think that their parochial interest must supersede the state interest. Why? What are they going to do this? One person, what are you going to do this?
Right. Let me bring in...
What is it?
Let me bring in counsel as well, because it looks like this morning all of our conversations are centered on corruption-related matters expected to be before the courts. Counsel, charges increased from 25 to 54. There are some friends of mine, lawyer friends, who said the first charge sheet was defective, and so it's no surprise that there's been an amendment. Did you see that yourself when the OSP filed the first charges against Mr. Hamid and the other 9?
I must confess that I have not followed it keenly, but I am very aware that the OSP brought the criminal action against the mentioned accused persons, and indeed they put them on smack shots and as criminals and all that. I remember I was on key points and I mentioned that it was not right. But the Constitution and Article 19 maintains that one is innocent unless proven otherwise. So the fact that indeed charges have been brought against them does not mean that you take smack shot of them and then you come and put it or circulate it on social media. It was more as if the OSP was waging an internet battle rather than a law court battle. And again, I just pray that indeed the amendment of the charge sheet would be sustainable, because a lot of Ghanaians are getting increasingly worried with the outcome of the works of the OSP. We are having to hear or see as well that yes, the OSP goes after people in a lot of pomp and pageantry, and there's this grandeur fashion in going about the legal work. But indeed, when it comes to the committing of the legal works, we don't really get that, and that has left a portion of the legal community to open their eyes wide to see what's going on. Indeed, that you read it out. I just pray that the charge sheet as amended increased from that number to 54. So you said it will not just be charge and count sufficient, but it should be something sustainable. That the elements would really be satisfied in order to impute the criminality as indeed the OSP alleges. Other than that, the OSP is going to have a heavy backlash in respect of its work, because it's beginning to cause doubt in the minds of people. I am not suggesting that the OSP is not doing its work, but I'm saying that it's not doing its work properly. But there is this perception out there that people are interested in seeing achievable results of the OSP than this hopes that then will be dropped, and then they're more like a pendulum that is fluctuating. So we all support anti-corruption drive, and we all give our support to the OSP, that anybody who is involved in corruption and corrupt-related matters definitely should be brought to book, and that is the position of many that believe in justice delivery.
All right, I'll pick your thoughts, Ms. Alangdon, then I'll go for this quick break. So we round up on ECG missing containers and the docket, if we understand, reports submitted to the Attorney General.
Well, I think the issue of the revision of the charges, well, is the OSP who's doing the investigation. If his investigations have established that there are other findings and he has done the necessary filings, that's fine. As to how defective or otherwise the initial charge sheet was, that one I am not sure.
I was speaking to counsel because I had a few friends of mine who we had conversation who said they had concern with the charge sheet as the OSP had initially put together. But yeah. So like I'm saying, I mean, that is another view. The important and this also is another reflection that not only the Office of the Attorney General, but the Office of Special Prosecutor also is under pressure because of the very high expectation, as counsel made reference to. There's a very high expectation on the part of Ghanaians about seeing that these things are being dealt with the way they expect. So I think not just a matter of waiting for some time and then coming up with a revised charge sheet, but from time to time to appraise the citizenry of what is going on, what new cases are being handled, for people to appreciate that there's some work is going on if they have not been able to deliver immediate results, like putting some people behind in front of a judge or behind in court and things like that. But if there's a communication management to let people know that yes, work is going on, various types of investigations, it will cool down the heads a bit.
Yes, and also give them room to do their work properly. So because nobody wants to go to court and not get justice. Both the accused and the prosecution must feel that they've got justice. The prosecution, if they've got a good case, feel that they've got justice. If somebody has been accused and the person too realize that the accusations are not right, they should also be able to go to court and feel that they've got justice. So these are the things that I think both the Office of Special Prosecutor and the Attorney General must make very clear to Ghanaians, so that Ghanaians appreciate that yes, they are working and that they want to do a good job at the end of the day. So I think that's what...
Right. You're still listening to 3FM 92.7. This is Sunrise, 18 minutes to the top of the hour. We're taking these spots of commercials. When we return, we talk ECG missing containers, because that dominated conversations massively at the start of the year. The big question was, are the individuals responsible going to be prosecuted? Now it appears all that lies with the Attorney General.